So, Mr. Valentine, would you unmute, join us, or I should, if I remember correctly, you'd like to be referred to as American National Valentine?
Present.
Okay. And is that how you'd like me to refer to you?
Yes, ma'am.
Okay. I don't remember that. So, sir, there was a warrant issued for your arrest back December 6th. You had posted bond on the previous warrant. We had a hearing, and that's what we're here about, is we're still pending trial. And you weren't, the pretrial services violation, that's right. We've got a positive UA from November 1st for THC and cocaine, November 20th, a dilute one, but concerned about THC and cocaine, November 22nd, a UA positive for cocaine. So that's why we're here today.
Cocaine is a hell of a drug.
And I remember in the past that you were representing yourself. Is that still your intention?
Yes.
Okay. So let me turn to the status to this warrant issue, and then I'll turn back to you. And Mr. Weston?
Your Honor, this time the state would be asking that the current bail be increased to $10,000. It was previously, the state previously asked that amount at arraignment. The court previously imposed $15,000. That somewhere throughout the process, the court decreased the bail to $5,000. He posted the bond for that amount, and which I believe he was released on October 29th. And within a month, we have all these pretrial violations. And so the state has substantial concerns about him not following the release conditions that he's required to follow, especially being on pretrial release for DUI. And so the state's asking that the court impose $10,000 bail at this time, and that he either posted or turned himself in.
So, Mr. Valentine?
So I object the state motion. The release conditions that were set were not returned. Ooh.
I can hear you.
Okay. Yeah, the release conditions that were set were not returned to its original state. The release conditions were only changed because the 3 charges were added. And once the 3 charges were dismissed, our release conditions were supposed to be returned to personal recognizance. There was other individuals when I was in custody that were in the same situation. The state brought charges against them, but the state didn't have the physical evidence yet, and they released those individuals on their personal recognizance and waited for the results, for the evidence to pursue those charges. But with me, the state is being prejudiced and tried to keep me with strict release conditions, even though the charges were dismissed.
Cocaine always seems to lure people into thinking they are untouchable. They act like just a little use won't matter when the court is watching. But the reality is far from that illusion. Even one slip can spiral into serious consequences. The law does not care about intentions or excuses. Every failed test adds weight to their case. It's not just about a positive UA. It's about showing complete disregard for rules and restrictions. No judge is impressed by self-justifications or excuses. Substance abuse and pretrial supervision is always a ticking time bomb. This is a reminder that choices carry consequences, and the court takes notice of every single one.
I'll come back to you, Mr. Valentine, but let me ask that particular question of the state here. So is the state ready to go forward to trial? You have all the evidence, all the discovery on this matter, or is there toxicology reports that are pending, or?
Based on my knowledge, Your Honor, there's no blood draw in this case. The state is ready to proceed. It was American National Valentine that did request the continuance of trial confirmation on 11/8.
So you've got everything. We got everything. Tox reports. Okay. All right. So back to you, Mr. Valentine. Anything else? I'm sorry. American National Valentine.
The state was awaiting the toxicology report for case number 4A0027328. Those 3 charges that were added on to the case was the reason why I was on the ankle monitor and working with friendship services. And so since those charges were dropped, I'm only on the case for my DUI, my first DUI. I never had any previous DUIs. It's my first DUI. I was only brought into custody for the extra charges that were added on, and those charges were dismissed. But the release conditions were never changed.
So
Even my
this
bail,
one-
they didn't even lower the bail. I had to argue with the court just to get the bail lowered, even though the charges were dismissed.
So this one is alleged from November 13th of 2021. And then I see that there was a January 1st of 2024 that was dismissed. And now it looks like that has been refiled with an arraignment date scheduled for January 14th. Don't know if you've gotten that in the mail yet
Yes,
or
I
not.
have.
Okay,
Yes, I have.
so, all right. So you're right. These conditions are only about the case alleged from November 13th of 2021. Gotcha. All right. And that's the court order on that matter. 1A730693 was the pretrial services requirement and the requirement of sobriety. All right. So you're saying that, and tell me if I'm wrong, you're saying that I should release you, set this on for trial, and what about conditions of release?
So the conditions to release, I should be back PR'd as I originally was with this charge. If on the other case, like how you said the case was refiled, it's going to be in January. If the state wants to set, release conditions for that charge, that should be done on that case. But they're two separate cases now.
All right.
Does that make sense?
When supervision fails repeatedly, it sends a strong signal to the court they see a pattern of disregard for pretrial rules. It's not just a minor slip or misunderstanding, it becomes a demonstration of irresponsibility, and non-compliance courts rely on supervision to ensure safety and accountability. Ignoring or sidestepping these rules only worsens the situation. The judge's patience has limits. Repeated failures forced harsher decisions and higher bail amounts. It's a simple cause and effect scenario in the legal system. No one gets to choose which rules to follow. Compliance is not optional when under supervision. The court will always act to enforce structure and control.
Yep, it does. And there was, all right. I guess I don't agree with you. There was a request to October 28th to change release conditions, and that was denied. I guess that was me from the court's docket. That's what I'm reading. And so that was considered already, and that was denied. So, and now I have these allegations from pretrial services. So, all right, Mr. Valentine, we've had difficulty with getting compliance while you're on release. We've had difficulty with getting into court. And so I am going to increase that bail amount because 5,000 apparently isn't working. And I don't know what else to do. Pretrial services supervision isn't working. And so at this stage, a 10,000 cash or bond bail needs to be posted. You're appearing on Zoom. So either post that 10,000 cash or bond bail by Friday at 3, or you're in custody by Friday at 3. So you make that decision. And then we'll have a hearing on, I'm going to set this, see, where are we? I'm just going to set everything for that January 14 day. And so that we've got everything together. What time that is, but you either, as I said, 10,000 cash or bond bail to be posted no later than 3 o'clock on Friday the 20th, or you're in custody by Friday the 20th at 3, no later than 3. So we'll set this hearing. The next hearing will be January 14th at 2:30. It's a pretrial. So, any questions about your obligation there?
Yes. What are the nature and cause of these charges?
Driving under the influence. You're charged with and driving while spending the 3rd degree. The complaints are in the court file.
And what is the criminal jurisdiction like? What's the nature of the causes? Is it
Nature of
under
the cause.
admiralty jurisdiction or common law jurisdiction?
Washington State, RCW 4661. Violation of the state law. You're in Thurston County District Court, which has jurisdiction over you, as it's alleged to have occurred in Thurston County.
But I'm asking, what's the nature and cause of the charge? Is it under a
That's what I'm
common
telling
law?
you.
Is it
No,
under
it's under
common law
RCW
or admiralty?
4661. It's under Washington
So-
state law.
Don't you have the
State-
duty to make the nature and cause clear to me, ma'am?
I
Do I
have.
not have a right to know the nature of the cause?
Yeah,
nature and
and I
cause?
have.
Here, we reach the moment of truth for Mr. Valentine. The court lays out the clear and simple options. He can pay the $10,000 bond and continue his life for now, or he can surrender and face the consequences in custody. Both choices are straightforward and leave no room for confusion. Yet in his mind, there's always a fantasy third option. This imaginary route ignores the rules and stretches reality. It's a dangerous game of hope against inevitability every second of freedom. Outside the law is temporary bench warrants are not something that vanish quietly. Ignoring the court's order only accelerates consequences. Choices matter, and the court is watching every move.
And you can put it to writing if you think there's something more. A bill of particulars might be something that would be useful to you to send to the prosecuting attorney's office. But
I requested
That's what I've
a
told
bill
you
of
today.
particulars. I've requested a bill of particulars, and I've requested the case transcript, and I've gotten neither.
yeah, it's not going to be transferred. There's nowhere to transfer it. You're in the correct jurisdiction here in
I said
Thurston
a
County.
case.
District Court.
I said I asked for a case transcript and a bill of case transcript and a bill of particulars, and I still haven't gotten it.
All right, we'll follow that up with the prosecuting attorney for the bill of particulars, and then the transcript. That would be from the court if you wanted an audio recording of the proceedings. All right,
Still
so,
haven't made clear the nature and cause of the charges, ma'am.
all right, well, I think I have. So you're to turn yourself into Thurston County Corrections no later than tomorrow by 3 p.m. or you can post 10,000 cash or bond. We'll have our next hearing January 14th, 2:30. And you stay clean and sober and law abiding, and you're still on pretrial services supervision if you're out of custody and you comply with them.
So is the prosecution under common law or under admiralty?
We're not going to go in circles here. You have an
I'm just asking
obligation to be.
I'm just asking you,
I
as
understand.
my
I've
right. Is it
answered.
not my right to know the nature and cause of the charges?
Yep. I've answered you,
So-
Mr.
so
Valentine.
which-
I'm not going to go in circles. You're in custody by Friday. Or post 10,000 cash or bond. We'll see you January 14th. That's all for today.
So why can't we go back to the original release conditions?
I've already made that ruling, sir.
And it was a void ruling. It's a void judgment.
So long, Mr. Valentine. We've talked. Be in custody by Friday or post your 10,000 cash or bond. We're done here.
So you're not going to honor your oath to
We're
uphold
done,
the
Mr.
Constitution.
Valentine. I'm honoring my oath and I've done exactly what I'm to do by state law and Constitution.
You haven't made
simply
clear the
disagree.
nature. You haven't
We're
made
done,
clear the
Mr.
nature and cause of
Valentine.
the charges, ma'am.
Please mute Mr. Valentine. I don't want him to say something that would be untoward for him. So we're done, Mr. Valentine. Turn yourself in by Friday or post your bond.
You can almost predict the path some defendants take. Ignoring reality seems tempting when the law is looming. That third option in their minds feels like clever rebellion, but cleverness has limits under legal scrutiny. The court doesn't operate on hopes or imagination. Every action or inaction carries immediate consequences. It's tempting to guess what they might do next. And often that choice leads to more trouble than relief. Reality has a way of catching up fast. The law doesn't wait for second thoughts. Every step matters. Every decision is recorded, and defiance rarely ends the way one hopes. If you've been following this story closely, you know how wild it gets. Every twist and decision in court has real consequences. Engage with the video if you're seeing the truth unfold. Hit like if you're impressed with how the court handled it. Hit dislike if you think things are going sideways. Drop a comment below and share your thoughts with everyone. Your opinions make the discussion richer and more interesting. Subscribe to the channel to stay updated on every courtroom drama. Turn on notifications so you never miss a new video. We break down the cases, the mistakes, and the lessons learned. This is where skepticism meets reality and facts over fantasy. I'm Team Skeptic, and I'll keep guiding you through the chaos.